My name is Mary Galligan. I'm with the law firm Galligan and Manning, where our practice focuses on estate planning, probate, and elder law. Today I have some important news to share with you. Very rarely do we have changes in our laws that happen quickly and affect huge segments of our population. But that's exactly what happened at the end of 2019 with the new Secure Act, which was signed into law on December 20th, 2019, and which went into effect on January 1st, 2020. This new law could profoundly affect the beneficiaries of your retirement plans, such as your 401ks, 403bs, and IRAs, and could result in consequences that you never intended. During this presentation, for convenience, when I refer to IRAs, that includes 401ks, 403bs, IRAs, and other similar accounts. Why are IRAs different from your other assets? They are different because they pass by beneficiary designation, not under a will, and they have not been subject to tax. In essence, they grow tax deferred, and the tax is paid only on amounts withdrawn. The result is tax-deferred growth and lower income taxes. This is beneficial for both the IRA owner and the beneficiaries. Today, I'd like to review with you how your beneficiaries were treated under the old law, what changes have been made that affect how your beneficiaries will be treated under their new law, and steps you can take to protect your beneficiaries from unintended taxes and liabilities. Under the old law, if the beneficiary of a retirement plan were an individual or a trust that qualified as a designated beneficiary, the beneficiary's life expectancy could be used to calculate how much the beneficiary had to withdraw from the inherited retirement plan each year. You may have heard this arrangement referred to as a stretch IRA. The amount a beneficiary must withdraw each year is referred to as the required minimum distribution, or RMD. Why is it important that the beneficiary's life expectancy could be used to calculate the amount of the annual RMD? The fact that the retirement account could grow on a tax-deferred basis, and the fact that the beneficiary was taxed only on the amounts taken out during a given year, resulted in the account gaining value and the beneficiary receiving more in the long run. Under the old law, the spouse had more options. If a spouse were named as beneficiary, he or she could roll the IRA over to his or her own name and designate new beneficiaries, such as their children. After their surviving spouse's death, the children could use their life expectancies to determine the amounts they had to withdraw from their inherited IRAs, allowing the accounts to grow tax-deferred and be taxed at presumably a lower rate, because taking smaller amounts out of the inherited IRA would not result in pushing the beneficiary into a higher tax bracket. Now, let's look at what changes were made by the new law. Under the new Secure Act, the general rule is that most non-spouse beneficiaries must withdraw inherited account balances within 10 years of the account owner's death. Most non-spouse beneficiaries may no longer calculate their RMDs based on their life expectancy. This means that a non-spouse beneficiary, such as a child of the account owner, must withdraw the whole amount of the IRA over 10 years. The beneficiary can do this equally over the 10 years or all at once, provided that the whole amount is withdrawn within 10 years of the account owner's death. There are exceptions to this general rule, just as there are with almost every rule. A spouse may still use his or her life expectancy to calculate RMDs. If a minor child is a beneficiary of an inherited IRA, the life expectancy of a minor child of the account owner may be used to calculate his or her RMDs, but only until the child reaches the age of majority. Age of majority is not defined in this Secure Act, and many states define age of majority differently. Without any further guidance, we probably have to look to state law to determine the age of majority. In Texas, that age is 18. If the beneficiary of an inherited IRA is a disabled individual or chronically ill individual, as determined under Social Security rules, he or she may use the life expectancy method to calculate RMDs. Another exception is made for an individual beneficiary of an IRA who is not more than 10 years younger than the account owner. So if the beneficiary is a sibling of the account owner or the account owner's unmarried significant other, this exception would apply so that the life expectancy method could be used. So it seems the biggest group of people most affected by the new law are IRA account owners who name their children, grandchildren, or other young family members as beneficiaries, and of course the children, grandchildren, and other young family members who are the beneficiaries. So what is the estate planning crisis that the new act has created? The immediate problem is that the new act has drastically changed how some estate plans work, causing unintended consequences, especially in the area of creditor protection. People who before January 1st, 2020, created an estate plan that they thought protected their children's inherited IRAs from creditors and divorcing spouses now may have estate plans that cause their children's inherited IRAs to be vulnerable to those creditors and divorcing spouses. Let me give you an example. Before January 1st, 2020, if a person wanted to protect his or her child's inherited IRA from the child's creditors and from being divided in a divorce, the person would name a trust for the child as beneficiary. Typically, that trust could include what we refer to as conduit provisions, meaning that the inherited IRA would stay intact for the child's lifetime. The RMDs would be paid to the trust, then the trustee, according to the terms of the trust, would distribute the RMDs to the child. The RMDs going to the child would not be creditor protected, but they would be relatively small because they would be based on the child's life expectancy. Many estate planning practitioners used these conduit provisions in the trust because they were considered a safe harbor for favorable tax treatment for the trust. But all that changed as of January 1st, 2020. Now, as a result of the Secure Act, the trustee must withdraw the whole amount of the IRA over 10 years and distribute it to the beneficiary. This leaves the beneficiary without the protection of a trust, so that after 10 years, the whole amount of the inherited IRA is available to creditors and possibly subject to division in a divorce. Now, a conduit provision in a trust could defeat the purpose of why the trust was created in the first place. So what steps should you take in light of the Secure Act? If you have an IRA that names a trust as a primary or contingent beneficiary, it is imperative that you consult your estate planning attorney to determine if any changes need to be made to your estate planning documents, especially if your goals include creditor and divorce protection for your beneficiaries. One solution we are suggesting to our clients is that they amend their estate planning documents to remove the conduit provisions from the trust for their beneficiaries. The amendment provides that the trustee can decide what amounts to distribute to a beneficiary instead of mandating that the amount the trust is required to withdraw from the IRA be distributed immediately to the beneficiary. The downside of keeping the IRA distributions in the trust is that the trust is usually taxed at a higher rate than the beneficiary. But giving the trustee the flexibility to decide which is more important, tax savings or creditor protection, allows the trustee to act in the best interests of the beneficiary. If your goals involve tax savings, you may wish to talk to your estate planning attorney about doing gradual Roth conversions, or if you are charitably inclined, using a charitable remainder trust to create an income stream for your beneficiaries with the remainder to charity. In addition to checking on whether you have a trust that needs to be amended, This would also be a good time to review your IRA beneficiary designations to make sure that they are coordinated with your estate plan. Your estate planning attorney can help you with that too. In any event, you need to find out if the new law has caused your estate plan to change in a way that you did not expect. You need to make sure that your plan does what you want it to do, and that the new law did not create unintended consequences for your beneficiaries. You can find out more about retirement planning and other estate planning topics on our website at www.galliganmanning.com. This is Mary Galligan thanking you for joining us in this presentation.